Sorry, mine. We cannot change our name because we use the UniSZA account, Liputra. So we cannot change it.
Oh, Mr. Gabriel, may I know, are you going to be, what's your time allocation? How long is your time allocation?
15.
15. Okay. Are you going to be the first or second?
I am the co-counsel and Risha is lead counsel. So Risha will announce the time that we need later.
Okay.
Sorry to interrupt, Chase. Once the participants have entered the group, please ask them for their names as well as the time allocations. You wouldn't have to brief them, right? Just their names and time allocations. You may ask them now. Chase, can you ask the respondents for their names as well as time allocation?
Yeah, I've asked Gabriel. For Alif, who has just joined the room, can you please turn on your camera? Alif, are you there? So may I reconfirm your name, Alif?
Sorry to interrupt. Respondents, can I know who's going to be the first respondent and the second respondent?
Just respondent is Visha, and I have.
All right, so we
Sorry,
are hearing some interference coming from your end. I believe it's because you have two different devices open at the same time. So I suggest that you mute one of the devices. All right. Okay, so if I understand correctly, Risha is going to be the first respondent and Gabriel is going to be the second respondent. All right, can we ask how many minutes you are going to speak?
Risha needs 70 minutes and I will use 13 minutes.
18 minutes.
I 13, Risha 17.
13? Sorry, may I just confirm? Did you say Risha is 17 minutes and Gabriel is 13 minutes? 1-3? May I, to bring to your attention, the minimum time allocated for each speaker should be 15 minutes.
So each of us use 15 minutes.
All right. Okay, sure.
For the participants that have just entered just now, may I know your name, please, for 1005 respondent?
Can we please change our name first because our name still 1005R. Thank you very much.
All right, sure. So I believe their names has been needs to be changed to 1005A. So Chase, do get their names and their time allocations right away. And then as soon as the judges enter, we should start the round.
Just checking my sound system. Am I audible?
Thank you very much for your time. We are team of 1005A with the first speaker as myself, saya Remal Agung Takataran.
And my name is Raihan Case Tufail Lubis.
I know the time allocation for speaker.
We will have 13 minutes of pleadings and 2 minutes of rebuttal.
And for each of you, how long is the time allocation for the first applicant?
I'm sorry, can we revise? We would like to have a 15 minutes of pleadings and 5 minutes of rebuttal with the total of 30 minutes. 35.
Thank you. We are going
sorry to interrupt. So currently we are waiting for 2 other judges to join us. So we will wait until 2:10, and after that we will start the round. Thank you.
So since it's already 2:10, so I think we should start now. So the participants, you may present your arguments.
Can we proceed with our argument? Right.
Yeah, you may start up.
Good morning from Jakarta, members of the tribunal. My name is Sahar, and I appear on behalf of the applicant, dated Republic of Azura, with my co-counsel, Mr. Case. I will be addressing procedural arguments on the first and second submission. I'll be speaking on this matter for 15 minutes, and my co-counsel will be addressing the arguments on the second submission, and he'll be speaking for 15 minutes. We respectfully reserve 5 minutes of rebuttal. Your Excellencies, if there are no preliminary inquiries, I shall continue to briefly explain the dispute between both parties that has been brought up upon this Honorable Court of Justice. Member of the Court, the dispute between the Republic of Azura as the applicant and the United Province of Roxana as the respondent arose since 1 September 2022. Tensions between the United Provinces of Roxana and the Republic of Azura escalated due to the development of a new hypersonic nuclear missile by the United Provinces of Roxana. The Republic of Azura pursued a multi-pronged approach to counter the perceived threat, increasing intelligence gathering efforts, engaging in a campaign to pressure the United Provinces of Roxana, and upgrading and modernizing their defense system. The United Provinces of Roxana have asserted their military advances are necessary to protect their sovereignty. That's what they so-called. On 29 October 2022, the United Provinces of Roxana deployed a hypersonic nuclear missile to turn the tide of the war and force the Republic of Azura to reconsider its aggressive actions. The missile was launched with a specific target of mine, which is Octagon, Republic of Azura's military command and control center. The Octagon was struck with an immense force, causing a massive explosion that instantly obliterated the military command and control center. The human toll of the attack was unimaginable, with hundreds of thousands of casualties reported in the immediate aftermath. On 2 November 2022, the United Nations Security Council convened an emergency session to address the escalating crisis between the Republic of Azura and the United Provinces of Roxana. The strategy, the Security Council strongly condemned the use of a nuclear weapon against the civilian populations, demanding an immediate ceasefire and calling for both parties to engage in a diplomatic negotiations to de-escalate the conflict, which brought us here today. Your Honor, from such circumstances, applicant would like to submit two procedural arguments, which are: applicant acted in accordance with international law by launching military attacks against United Provinces of Roxana and need not pay reparations for the damage suffered. And respondent violated international law in targeting Octagon with its hypersonic nuclear missile and must pay reparations to the Republic of Azura for the damage suffered. If it pleases Your Excellencies, I will begin with the first argument. The Republic of Azura legally self-defends in the need of preserving self-defense. Respondent hypersonic nuclear missile clearly made an imminent threat towards the stability and integrity of international life. The Electronic Code of Federal Regulations define imminent threat as a substantial natural occurrence that could cause significant damage to property or threaten human life in the near future. Respondent hypersonic nuclear missiles meet the requirements to be classified as an imminent threat due to operational range that could...
Agent, are you able to hear me?
Yes, Your Excellency.
Okay, so I have a question. Under Article 51 of the UN Charter, to exercise your right to self-defense, what are the criteria that you have to fulfill or the other party to fulfill in order to exercise the right to self-defense? That is number one. Number two is the extent of self-defense that you're exercising. Is it preemptory self-defense or the anticipatory self-defense? Either one, whatever you argue, would you please give me the basis of your argument as to whether there is an objectively existing armed attack that allows you to exercise your right to self-defense under Article 51?
Right. Thank you very much for your question, Your Excellency. If we refer from Article 51 of the UN Charter, it is stated that if self-defense, it must be for two reasons. First of all, it needs to have serious attacks or an armed attack occurs in the nations. And second of all, the nations which conduct the rights of self-defense must immediately report it to the Security Council. Therefore, the two reasons are the main reasons for an action to be called self-defense, which is an applicant clearly experiencing an imminent threat towards the respondent, which by the respondent clearly made a hypersonic nuclear missile, which potentially risk the life of the regional community and even the whole world. I believe that concludes my answer, Your Excellencies. May I continue with my argument?
Please, yes.
Thank you very much. Respondent hypersonic nuclear missiles met the requirement to be classified as an imminent threat due to operational range that could potentially place its major series and military installation at risk. While applicants are highly aware that the respondents are in no position that they have already ratified the non-proliferation of nuclear weapons, nor the Comprehensive Nuclear Test Ban Treaty. However, the Comprehensive Nuclear Test Ban Treaty, or CTNBT, has made it clear that any nuclear tests were highly prohibited, as they will produce grave injuries towards many aspects of life. Also, during the missile's launch, the rocket exhaust will release large amount of pollutants, including nitrogen oxides, carbon monoxide, and sulfur dioxide into the atmosphere. Secondly, the detonation of the nuclear warhead will release a significant amount of radioactive material into the air. Finally, the high speeds and temperatures involved in the hypersonic nuclear flight can cause atmospheric heating, leading to the creating of ozone and other harmful pollutants. Your Excellencies, this is very hazardous for all of the peace of humankind. Referring to the Operation Desert Fox, a 1998 four-day British and American bombing campaign against chemical and biological weapons facilitated in Iraq, while the potential use or target for Iraq's weapons was unknown. Operation Desert Fox was not condemned by the UN Security Council. Tacit approval was given for the preemptive use of force in order to counter a threat which was not yet demonstrated to be imminent. Thus, in relation to this case, while the hypersonic nuclear missiles have not shown any sign to be an imminent threat towards applicant, the respondent's military activity and nuclear weaponry tests clearly made it an imminent threat towards international peace. Members of the court, respondent missiles easily classified as an imminent threat, as the missile had an operational range that could potentially place its major series and military installations at risk. Hence, it pushes the need for preventive measures. The preemptive self-defense was done accordingly to the Caroline incident, the doctrine of anticipatory use of force against an imminent threat. The British Crown had the right to preemptive self-defense if there was a necessity of self-defense, instant, overwhelming, leaving no choice of means and no moment of deliberation. Based on Webster formula, the doctrine of anticipatory use of force consisted of four key components: the immediacy of the threat, the certainty of the threat, the necessity of the armed response, and the proportionality of armed response. This threshold has been fulfilled, Your Excellencies. The immediacy of the threat is evidenced by how imminent the damage will be from this dangerous missile, as it could potentially place major cities and military installations at risk. The certainty of the threat is evidenced by several high-profile military exercises and test launches, showcasing the capabilities of their conventional and nuclear forces. These acts were in contrast towards their military advancement purposes, which they quote as purely defensive in nature and necessary to protect their sovereignty. The missile also brings several negative impacts, Your Excellencies, such as releasing a large amount of pollutants, including nitrogen oxides, carbon monoxide, into the atmosphere during the launch. Secondly, the detonation of the nuclear warhead would release a significant amount of radioactive material into the air. Finally, the high speeds and temperatures involved in the hypersonic can cause atmospheric heating and the fast pace of danger to our climate. The necessity of the armed response is evidenced by the need to neutralize the nuclear missile, as the United Provinces of Roxana were not bound by any nuclear treaty. This could mean that respondents could exercise their right of use over nuclear weaponry. The proportionality of armed response is evidenced by the main objective of Azura preemptive strike mainly were for military objective, to neutralize the development of the threatening missile. Therefore, Azura military installation is justified as it was done accordingly to customary international law. Your Excellencies, moving on to the next topic, Azura do not have any obligation to compensate on account of not committing any wrongful act as the strikes on power plants, transportation networks, and command and control centers, as it is rendered necessary in order to weaken Roxana military forces. I believe it concludes all of my pleadings. If there are any no more questions, that is my pleadings. May it please the court.
Thank you, Your Excellency. As introduced previously, my name is Raihan Kestufelubis, and I will be speaking for the arguments on behalf of my client, the Republic of Azura, with the second submission. We submit that United Province of Roxana violated international law in enacting the launching of nuclear missile towards the Octagon. Your Excellencies, United Province of Roxana use of nuclear weapons were in contrary to the rules and principles of international law. Deployment of nuclear weapons has the capabilities to endanger all human life, and is an act of gross human rights violation given nuclear weapons destructive capabilities. Not only it doesn't really distinct between civilian objects and military objects. The deployment itself is potentialized to constitute a war crime and crimes against humanity. If Your Excellencies, if you would follow me to Article 8, Paragraph B, Chapters 1, 2, 4, and 5 of the Rome Statute, which in essence summarize that nuclear weapons have a tremendous effect in that all nearby items, facilities, and structures might sustain damage that could flatten the area. In addition,
you're referring to the Rome Statute, which is the statute for the International Criminal Court, right?
Yes, Your Excellency.
Right, but this is International Court of Justice. Do you submit that the provisions of the Rome Statute would be binding on this court?
I'm sorry, Excellency, Your Excellency. I plead the fifth.
Sorry?
I plead the fifth.
Okay, proceed.
Thank you, Your Excellencies. Respondent nuclear missiles also qualify as a crime against humanity as it is written under Article 7. Given that the nuclear missile that hit the Octagon not only devastated the city center, but also the neighborhoods around it, it was claimed that what the respondents had done was prohibited. It can be proven by the legal facts that the human toll of the attack was unimaginable. Therefore, the act of deploying nuclear weapons potentially endangers human life and is an act of gross human rights violation. Moving on to the next topic on the safe submission, Roxana's nuclear missile launch breached the principles of rules and the rules of humanitarian law. Firstly, the launch of hypersonic nuclear missile breached the principle of proportionality. According to the legal statement of facts, the missile struck its intended target, the Octagon, with great power, setting off a huge explosion that instantaneously destroyed the military command and control center. Also, the explosion shock waves tore through the metropolis, destroying entire city blocks and turned them into rubble. Due to the imbalance created between the military strikes and the civilian targets, the respondent broke the proportionality norm of international humanitarian law. Your Excellencies, if we're talking in the context of proportionality, I would like you to follow me according to Article 51 of RCWA, as it is stated that countermeasures must be commensurate with the injury suffered, taking into the gravity of the international wrongful act and the rights in question. Now, As I have said before, the nuclear strikes not only devastated the command and control center, alias Octagon, but also turning the neighborhoods and the area around the Octagon into rubble, which in this case, stated in Article 51, Paragraph 1 of Geneva Convention Protocol, as it is stated that civilian objects shall not be object of attack or of reprisals. An essential idea in international humanitarian law that controls how armed conflict is conducted is the principle of proportionality. It specifically refers to when force is used during military operations, especially when civilians may be harmed. Attacks are judged disproportionate and as a result illegal under international humanitarian law if they do more harm to civilians or civilian property than the expected military advantage. Henceforth, the actions of the respondents not only involve striking military targets, but also all civilian targets. And the use of hypersonic nuclear missiles even put civilian safety in danger. As a result, the respondent broke the proportionality principle. Your Excellencies, continuing to the argument of the breach of international law, the launch of hypersonic nuclear missiles breached the principle of distinction. As I have said before, the nuclear missile launched towards the Octagon gravely breached the basis of distinction, as it is also injured many civilian objects and left a human toll to disaster. Under Article 57 of Additional Protocol to the Geneva Convention relating to the protection of victims of international armed conflicts, stated that in the conduct of military operations, constant care shall be taken to spare the civilian population, civilians, and most importantly, civilian objects. With respect to the attacks, the following precautions shall be taken. Those who plan or decide upon the attack shall, first, do everything feasible to verify that the objective to be attacked are neither civilians or civilian objects and are not subject to special protection, but are military objectives within the meaning of paragraph 2 of Article 52, and that it is prohibited by the provisions of the protocol to attack them. Your Excellencies, continuing with the Article 51, paragraph 4 of the Additional Protocol 1, prohibited indiscriminate attack. Indiscriminate attacks are those which are not directed at a specific military objective. Second, those which employ a method or means of combat which cannot be directed at a specific military objective. And third, those which employ a method of means of combat, the effects of which cannot be limited as required by this protocol, and consequently, in each such case, are of a nature to strike military objectives and civilians or civilian objects without distinction. Additionally, an attack by bombardment of by any methods or means which treats as a single military objective a number of clearly separated and distinct military objectives located in a city, town, or village, or other area containing a similar concentration of civilians or civilian objects are also considered as an indiscriminate attack, which is prohibited under Protocol 1. Therefore, the respondent has done a wrongful act and violated Protocol Additional to Geneva Convention of 12 August 1949 and relating to the protection of victims of international armed conflicts under Protocol 1, 8 June 1977. Your Excellencies, I have reached the end of my pleadings. If there are no further questions, that concludes my submission. Thank you for your audience.
Thank you very much.
Sorry to interrupt, and then would you like to continue asking questions, or we just move to respondent?
We can move to the respondent, please.
Okay, sure. So respondent, you may proceed.
Pardon?
May I proceed with my argument?
Yes, you may start.
Please do.
Thank you. Your Excellencies, may it please the court. My name is Shisha Zubitli, a lead counsel for United Provinces of Roxana. I will submit for the first 15 minutes, and my co-counsel, Gabriel Anakonggit, will submit for
Really,
another 30 minutes.
sorry to interrupt, respondent. Can I make sure has the second applicant and their submission?
Yes, we have finish our submission.
All right, okay, sure. So, first respondent, you may begin from the beginning.
Uh, thank you. Your Excellency, may it please the court. My name is Risha Zulkifli, a lead counsel for United Provinces of Roxana. I will submit for the first 15 minutes, and my co-counsel, Gabriel Anak Unggim, will submit for another third 15 minutes. We reserve 5 minutes for the rebuttal. Your Excellencies, we submit that Republic of Azura has violated international law by launching unwarranted military attacks against Roxana and is liable for reparation under 4 conventions, which are: first, absence of armed attack and self-defense; second, violation of principles of proportionality and necessity; third, obligation to pay reparation; and the last one is Republic of Azura violated principles of sovereignty and interference. While my co-counsel will deal with the second issue. Your Excellencies, before I continue with our first issue, may I proceed with the statement of factors?
No, I don't think I need to hear the fact. I want you to please move to the arguments.
Much obliged. Your Excellency, our first contention is that there was an absence of armed attack and therefore no justification for self-defense by Azura. The right of states to defend itself as enshrined in Article 51 of the United Nations Charter is triggered only if an armed attack occurs. However, the International Court of Justice judgment in the military and paramilitary activities in Nicaragua case provides a valuable guideline. In this case, the development of a hypersonic nuclear missile by United Provinces of Roxana is perceived as threat and cannot be classified as an armed attack. This was clarified by the International Court of Justice in the Corfu Channel case, where it held that the mere act of posing threat does not justify a response under self-defense. Moreover,
Agent, I understand that you submit that there has not been an objectively existing armed attack, but at the same time, if you look at Article 2.4 of the Charter of the United Nations, along with the existence of an armed attack, the use of threat of force is also applicable in order to apply the rules of self-defense. Do you submit that there has not been a threat of use of force when your state is preparing nuclear products? Is that a threat of use of force to the applicant party?
Your Excellency, to answer your question, according to the Moot problem that we have received, our nuclear missile cannot be considered as a threat. It is the one who applicant considered our nuclear missile as a threat. Furthermore, our nuclear missile is for the purpose of research and to protect our sovereignty. I hope I answer your question.
Okay. So in order to protect your sovereignty, you're going to use the nuclear missiles, right? But when you use that missiles, it's not going to affect only one country. It might affect the neighboring countries as well. So is there anything in the fact sheet which provides that you made it absolutely clear that there won't be any threat to use of force to any of the neighboring countries while you are building your nuclear missiles?
Your Excellency, to answer your question, according to our research and development, there is no intention to use the nuclear missile to attack another state. According to the clarification as stated in question 27 in paragraph 9 of the Moot problem, it states that sovereignty and interest in government of the United Provinces, referring to the belief that developing of hypersonic nuclear missile was necessary to protect the nation's territorial integrity and national security. I hope I answer your question, Your Excellency. May I proceed with my argument?
Yes, please.
Thank you. Your Excellencies, I now turn to our second contention, which is that Azra violated the principles of proportionality and necessity in its military attack against Roxana. According to Article 51 of the Additional Protocol 1 to the Geneva Convention, an attack that may cause damage to civilian objects which would be excessive in relation to the expected military advantage is explicitly prohibited. Relating to the case, UNSZA targeted the economic sources, causing a huge loss to Roxana. Your Excellencies, UNSZA is obligated to pay reparation for Roxana. The articles mentioned in Responsibility of States for Internationally Wrongful Act 2001 sets a clear precedent for our argument. Perhaps I would like to draw your attention to Article 51 and Article 36, which states that full reparation must be made for any injury caused by an internationally wrongful act. Of particular relevance, in the case of Germany against Poland, which emphasized the legal obligation to make reparation. A main point for our case is the principles of state sovereignty and non-interference as enshrined in the United Nations Charter, specifically in Article 2, Clause 4, and the Declaration on Principles of International Law concerning friendly relation and cooperation among states. Sovereignty, as we all
Okay.
know, is
Agent, the
fundamental.
document that you're referring to, the Friendly Relation Resolution of the United Nations General Assembly, is that it's a resolution, right? Is it binding on this court or is it binding on any of the parties?
Your Excellency, to answer your question, the law is not binding, but the same principles is applicable since it has been stated in the customary law.
What is the authority behind saying that it is a source of customary international law?
Your Excellencies, may I have a moment, please? Okay. Your Excellencies, to answer your question, under the United Nations Charter, specifically Article 25, member states of UN agree to accept and carry out the decision of the Security Council. Therefore, resolutions passed by the Security Council are generally considered binding for the members of states they apply to, which means under the United Nations Charter, both of the countries are binding. I hope that answers your question.
Proceed.
May I proceed with my argument? Your Excellency, as for our last contention, Republic of UNSZA violated the principles of sovereignty and non-interference. UNSZA's military intervention constitutes a clear violation of the principles stated in Article 2, Clause 4. UNSZA launched a preemptive attack against Roxana without a legitimate basis under international law, coordinating an assault that we assert to be an interference in Roxana's sovereign rights. Moreover, according to the Article 2, Clause 7 of the United Nations Charter, UNSZA's action in destroying Roxana's property constitutes an infringement on Roxana's internal affairs. Hence, we maintain that the Republic of UNSZA's action violated the principles of sovereignty and non-interference under international law. Therefore, we submit that Republic of UNSZA has violated international law by launching unwarranted military attacks against Roxana and is liable for reparation. If there's no further question by the floor, I will end my first submission here and my co-counsel shall proceed with the second issue.
Okay, thank you.
May it please the court. Your Excellencies, and is Gabriel and co-counsel will continue with the second issue in which we submit that United Province of Ghana did not violate international law in targeting octal hypersonic nuclear missiles and is not like for the reparation to Republic of Azura for the damage suffered based on three contentions. First, United Province of Ghana has right to peaceful use of energy nuclear technology. Second, United Province of Ghana did not violate non-proliferation weapon there is legitimate defense measure on Rosanna's part. Your Excellencies, for the first contention, the United Province of Zana has right to peaceful use of nuclear technology. The Treaty on the Non-Proliferation of Nuclear Weapons, specifically Article 4 and other international instruments such as the Statute of the International Atomic Energy Agency, IAEA, also deal with the peaceful use of nuclear energy. According to Article 4 of the Treaty on the Non-Proliferation of Nuclear Weapons, state that the unalienable right of state parties to research, develop, and use nuclear energy for non-weapons purposes. By applying both treaties, United Province of Zana had the right to develop hypersonic nuclear missiles to show sovereignty its over territory and advance next-generation weapon system. To summarize the reasons, we respectfully submit that United Province of Zana can develop the hypersonic nuclear missile based on the above treaty as long as the development of the hypersonic nuclear missile was not for attacking the others member that joined both treaties. Your Excellencies, now I'm going to move to next contention. United Province of Rosanna did not violate non-proliferation of nuclear weapons. Based on Article 3 of NPT, each non-nuclear weapon state party undertakes to conclude an agreement with the IAEA for the application of the safeguard to nuclear material in all of the state, peaceful nuclear activities, and to prevent diversion of such material to nuclear weapons of other nuclear explosive devices. This is related to the United Province of Rosanna as a non-nuclear weapon state to develop hypersonic nuclear missiles just for the peace, sovereignty, and security, meaning that Rosanna action could be interpreted as demonstration of a nation's right to self-defense based on Article 51 of United Nations Charter. Depending on Iran case before the International Atomic Energy Agency is instructive, Iran was deemed to be violation of its NPT obligation, resulting in the imposition of international sanctions. Based on Article 10 of the NPT, confers the right to withdraw. This article allows parties to resign from the treaty if they determine that extraordinary events related to the subject of the treaty have jeopardized their most important interests. We believe that if Rosanna decides to invoke Article 10 in the NPT, it must be identified the extraordinary event that have threatened its most vital interests. Ben on my late counsel mentioned about principle of proportionality and necessity. Rosanna can withdraw from NPT if Rosanna is not allowed to invoke self-defense based on this principle. The example of Democratic People's Republic of North Korea announcing its withdrawal with prompted discussion, particularly regarding whether it met procedural requirements. This emphasized the significance of the nation's self-governance. In summary, we respectfully submit that the United Province of Rosanna does not violate the NPT because it complies with Article 51 of the Nation Charter, in which member of the Nation Charter, United Nation to employ the principle of self-defense. Your Excellency, I will proceed to with last condition. There is legitimate defense measure on Rosanna's part. The most
Yes,
important
but
detail
before
can be
you move on to your next contention, do you have any arguments based on the environmental impact of the nuclear weapons that you have?
sorry, Your Excellency, may you rephrase your question again?
Certainly. So there is going to be an environmental impact for the use of the nuclear weapons that you're building. Do you have any arguments to suggest or maybe support the fact that the nuclear weapons that you are building will not be hazardous for the environment?
May I please a moment first for answer the question?
Yes, yes.
To answer the question, violation of environmental law principle, the development of hypersonic nuclear missile by Azura can be considered as violation of key principle of international environmental law. This principle includes the obligation to ensure that the activities within a nation jurisdiction to control thus do not cause damage to the environment in other states to the United Province of Rosanna, to the Republic of Azura. So it's mean that yeah.
Proceed with the arguments, please.
Okay, so it's mean they have nuclear hypersonic to the United Province of to Republic of Azura. The launching attack using the hypersonic nuclear missile can cause damage to the environmental to Republic of Azura, but it is the only way that United Province of Rosanna can use to deter the attack from United from Republic of Azura. Is the answer your question?
Yes, please proceed.
Your Excellencies, I will proceed with class contention that is legitimate defense measure on Rosanna's part. The most important detail can be seen in Article 51 of United Nations Charter, describe the inherent right of individual or collective self-defense if an armed attack occur against a member of nations and that the specific action of Azura lead Rosanna to respond would need to be detailed and analyzed in relation to precedent and the definition of an armed attack. Additionally, the principle of necessity in international law states that state's response to an armed attack must be necessary to deter or repel the attack based on the case Nicaragua against United States, and that the response should be proportionate, not excessive in relation to the threat posed. Finally, the response was proportionate and necessary to the situation as crucial infrastructure of civilian objects were destroyed when there was uneven development across the state of Rosanna. Therefore, we submit that Therefore, we submit that United Province of Rosanna did not violate international law in targeting Octagon with its hypersonic nuclear missile and is not liable to pay for the reparation to Republic of Azura for the damage suffered. Thank you for your attention, Your Excellencies. I stand ready to answer any question for the floor.
No, thank you.
Okay, thank you, Your Excellencies.
Bailiff, I think we're done with the submissions. We can move to the rebuttal, sir. Rebuttal.
Yeah, the applicant team should proceed to the rebuttal session.
Okay, for my name is Raihan Kais, and I will proceed with the rebuttals. Respondent clearly agreed to risk the life of many and hazarding our climate, which is already in decline. Your Excellencies, the act of launching nuclear missiles are an act of selfish and risking and endangering the peace and security for the whole world. Also, respondent clearly breached the fundamentals principle of IHL as written in API, Additional Protocol 1, especially limiting unnecessary suffering. I will refer you to Article 35 of Additional Protocol first, as it is prohibited to employ weapons, projectiles, and material methods of warfare of a nature to cause superfluous injury or unnecessary suffering. The use of nuclear deployment to the whole city and the use of nuclear weapons on the whole city not only not only killed civilians per se, but also destroyed civilian objects. And this clearly is an inhumane way of killing. Different from applicants, we are launching preemptive strike, but we strictly attack military installations and transportation networks and power plants, which the applicant may refer to Article 52 of Additional Protocol 2, where Attacks shall be limited strictly to military objective. Insofar as objects are concerned, military objectives are limited to those objects which by their nature, location, purpose, or use make an effective contribution to military action. However, even if it's not included in statement of facts, power plants and transportation networks are deemed useful for military logistics efforts to hit are useful for military efforts as applicants' attacks are purpose is to hinder and neutralize the nuclear research. Also, applicant, we even facilitate from humanitarian organization to provide necessary helps for children and for civilian and civil objects. Thank you. That will be all. May it please the court.
Thank you very much.
Your Excellencies, may I proceed my rebuttals?
Yes, please.
Thank you. May it please the court, Your Excellencies, my name is Risha Zulkifli and I will submit the rebuttals under 3 main points. The first one is the application of self-defense by Azura is not applicable. Second, the development of Roxana's nuclear missile does not violate NPT. Third, Azura needs to pay reparation to Roxana. Your Excellencies, the first rebuttal is the application of self-defense is not applicable in the case of Azura. Just now, during the argument, applicant mentioned about the meaning of self-defense. We have to attack another state when there is leaving no choice of means. But according to the Moot problem, Roxana did not possess anything or any attack first in this case. Secondly, under the doctrine of self-defense, we must fulfill 2 circumstances, which is necessity and proportionality, and also armed attack. But in this case, Roxana did not initiate any attack to Azura first. So, therefore, the application of doctrine of self-defense is not applicable in the case of Azura. Your Excellencies, the second reason is the development of Roxana's nuclear missile does not violate the NPT. Your Excellencies, as I mentioned before, the development of hypersonic nuclear missile by Roxana is mainly to protect its sovereignty and also for the military advancement and military purpose. This falls under Article 4, which is the exception to the non-proliferation article. Article 4 of the Treaty on Non-Proliferation states that a state can or may develop any military object if it's for the purpose of research and protects its sovereignty. Therefore, we submit that the development of Roxana's nuclear missile does not violate the NPT. Your Excellencies, as for our last reason or our last point, Azura needs to pay reparation to Roxana. According to the case of Germany against Poland, 1928, the damage suffered by the Poland as a result to the World War II is Poland lost the eastern half of its territory, which means Poland has lost most of its economic resources. Relating to this case, Azura has attacked Roxana's military resources, which also means that Azura already attacked Roxana's main economic system. May I redirect you to the Moot problem, page 11, paragraph 20, which stated that during the attack of Azura towards Roxana, Azura utilized its land, air, and naval forces in coordinated assault, which means that Roxana has suffered a huge loss in terms of economy. So referring back to the case of Germany against Poland, the court held that the reconciliation was founded by Poland, whereby Germany must pay reparation compensation in terms of monetary in total of 7.97 billion due to the damage suffered during the warfare. Therefore, we submit that in this case, Rosanna has not violated any of the international law. Thank you for your attention. We
Thank
end
you
our
very
rebuttal here.
Thank you.
So, Your Excellency, I think that concludes the round. So now the participants will be moved to the breakout room. Sorry for the technical issue just now. Your Excellency, are you here?
Hello. Yes, I'm so sorry. Am I audible now?
Yes.
Okay.
So please note that we have up to 15 to 20 minutes for you to complete your score sheets. Kindly score the participants' performance based on the provided criteria. Once
Right.
completed, please email the score sheets back to the organizer at Competition Alliance ILSA UniSZA.my.
Right.
So please take your
I
time.
need your help for one thing, which is, could you please confirm that the first, the applicant team was 1005, right?
Yeah.
And the respondent team number?
1001.
1001. And I also do not have the names of the applicant team. I also do not have the name of the respondent's second member. Do you think you can provide me the names through WhatsApp or maybe the email?
Sure.
Because they did not
I
have the
just-
names on their screen. I could not note down the names.
Okay, so I just text you directly on WhatsApp to send the
Sure.
names. Okay.
Sure.
Mm. Mr. Razia, I think I've sent you their names on WhatsApp. Have you received?
I got them. Thank you so much. I'm finishing up my score sheet, then I'll let you know. Okay.
Okay, thank you.
I just sent this score sheet.
Hold on, yeah. Let me check on our email. They received. Thank you, Mr. Raji. We have received the.
Thank you. Go back to the room and give feedback to the participants.
Yeah. They will be joining us later. Mr. Raji, the participants will be joining us now.
Okay, thank you so much.
Welcome. Mr. Raji, we may start the feedback session now. Participants are all here.
Thank you. Hi, everyone. I hope you guys had a wonderful day. I will just give you a few feedbacks based on the performance that you've done. First of all, congratulations on participating in this competition. The mood problem in itself is very complex. The rules of international law and the issues of international law, it's very complex. And I can see that you guys have worked really, really hard. That shows in your performance. I'm really, really happy to be a part of it. I will just give a few feedbacks to individual performers. First of all, applicant one, I think you did very well in terms of your oral advocacy and how you present the laws and how you connect the laws with the relevant facts. I think you did quite well. You also did very well in terms of question answers. I think you've been very interactive. But one thing that I would suggest you is that I can understand that we all have this tendency of looking at the script too much. But if we look at the script too much, we simply cannot just look back to the judges because we feel like maybe we will miss this line, that line, it may be important. What I would suggest and what I have understood from your performance is that if you did not rely on the script and just spoke to me randomly and candidly with about the facts and the knowledges, I think you would have done much, much, much better. Not that you did bad, but it would have been even better because when you were answering the questions and you weren't looking at the scripts, I found you more knowledgeable, and I found your research to be more extensive. So that would be my suggestion for you. For applicant two, your way of presentation style and poise is very nice. It's very commendable. I think you have very good grasp of the language, which is very, very commendable. One thing that I would suggest and highly, highly recommend is that when we are in a courtroom setting, even if it's a competition, even if it's a moot court and not a real court, we have to be very respectful towards the court, the judges, and the respondent team or the opponent party. The reason why I'm saying this is because I understand that this is an online setting. If you have to talk to your teammate after your submission is over, you can turn off the camera and speak to your co-counsel or co-agent. But when you do that in front of the camera and you're smiling, maybe you're talking about something fun, which is completely understandable. I have done that too, but I would turn off the camera because I don't want the judge to see what I'm doing, because that would make the judge feel that you're too confident and laughing at the respondent, so that would make me feel, oh, so they're demeaning the respondent, I will give them less marks. Okay, so every time you have to interact with your teammate beyond the submission part, I want you to turn off the camera, and every time you turn on the camera, you have the camera turned on, you be very respectful and very composed and very formal towards the other people in the courtroom. And I really liked when during the submission you guys were interacting. I think you were looking at your teammate for confirmation that is this the answer. This is very cute, but you cannot do that, because if you do that, I feel like you don't know anything. Everything you're saying is prepared by your teammate. That's what I, as a former mooter, would think, that maybe his teammate prepared the script for him. He's now reading it, and when he needs to say something, he has to look at his teammate. Hey, is this right? Right? Don't do that. Whatever you have in your mind, yes, no, very good, just say it. And I'm going to, the judges will understand that you're trying at least. Okay. But other than that, the team is very nice. It's a very friendly and very sweet team, I would say. So very best of luck for the future rounds. For respondent, respondent one, Risha, very well done. I think it shows in your work that you're working very hard. I saw during the session that you're taking notes, you're very serious, you're helping your teammate. It's very commendable. It's very commendable, not only as a mooter, but I think as a person or as a law student. I would like you to pursue this mooting and advocacy in the future. I want to see you in the international rounds. That's what I mean. And I think one thing that you shouldn't do is when you refer to a law to me, the only thing that you can ask me to look at, you say that, Your Excellency, I drive your attention, or if you look at article this of that law, let's say you're talking about the Rome Statute, or let's say you're talking about the resolution 2625. I do not have that in front of me. Have is the moot problem and the official rules and the clarification. That's all I have, or maybe I have your memorial. So if you have written that in your memorial, you say that in my memorial, page number this, I wrote this, you can look at it. But when I don't have those additional materials, because mooting is, the moot problem is so vast, you can bring anything in the world, any law in the world that you find relevant. But I do not have access to that law. I don't have it prepared in front of me. So I have to search it on Google that, okay, Rome Statute, maybe I don't know what Rome Statute is. I will go and search Rome Statute, then article. By that time, your time is gone, you're gone, everything is, I don't know what's happening. So you only refer to the laws that you think I might reasonably have. Maybe I will have the UN Charter, of course, because that's very common. I will have the ICJ statute. I will have some of the very common things, maybe the resolution 2625, because it's very common. When I was asking you about the question of the authority of why you are saying it's a customary international law, I know that it is a customary international law, but I want you to tell me that it is a customary international law because this court, the ICJ, in that case, said in that paragraph that the friendly resolution is a customary international law. If you just say that, just mention the name of the case, I will be very much convinced. But other than that, it shows that you worked really hard, your research is very well, and I think if you just practice a little bit more of speaking, you will do very well in the future. So my very best wishes. Respondent 2, I'm very happy with your submission. You've done well. But what you have to do is, even if it's an online setting, you have to be very careful about where you're placing your camera. So you have to place your camera in front of your eyes, not down, down the chin, because I cannot see what expression you're giving me. I don't know if you're looking at me. I don't know what you're doing. It's very difficult for the judge to understand. So from the next rounds, maybe your teammates can help you to fix the camera. And other than that, your way of answering question and your way of relating the laws to the fact was very well. I think you need a little more practice and little more confidence. The confidence will only come when you do more research and read more and more and more. The same things, maybe your own memorial, if you read it twice or 3 times, I think your confidence will be automatically upgraded. So that will be all from me. And I'm very happy to take this session. I wish my other co-judges were here. That would have been more fun, but I'm very happy to be a part of your journey and on the very best. Of course, Bailiff and the organizers, you guys have done a fantastic work. I'm very happy to be a part of this competition.
Thank you, Your Excellency, and all the participants. So I think that's the end of second round. So The participants, you may leave our meeting now. And also for Mr. Ratzi.
All right. Thank you
Thank
so
you.
much. Thank
Thank
you for
you.
having me. See you. Bye-bye.
Thank you very much, Mr. Razi. Mr. Miss.
Thank you, everyone.
The judges. Sorry. Is anyone in the room?